Welcome to the Consultation. We're going to talk to you guys about grandparents' rights. We've done one video already, or one podcast already on grandparents' rights as it relates to possession and access. But this time we want to talk to you about how it relates to conservatorship. So my name is Josh Floyd. This is Christina Jimenez. We are both attorneys at Jimenez Law Firm. And today we're going to discuss grandparents' rights as it relates to conservatorship. What say you?
I say that it's still difficult to get conservatorship rights.
More or less difficult?
I'd say it's less difficult than getting possession of or access to a grandchild just based on the statute. But I think it depends on the fact pattern, right? The facts of this particular case.
The outcome of a case depends on the facts.
It does.
Novel. Okay.
I have all of the really good information
Mind
over here.
blown.
So it depends on what you have going on, right? So statute states that...
Do you remember in law school, they told us the answer to every question is, it depends.
Yes, that is a true statement.
Whether or not you passed or failed is if you knew what it depended on.
That's
so
a true statement.
We all know it depends, right? But what does it depend on? So we were talking about conservatorship as it relates to, or grandparent rights as it relates to conservatorship. And I believe we were diving into the code here about exactly how that can happen. So what do we need to do? What do grandparents have to prove?
So first things first is you have to prove standing, okay? And that's in basically any case, not just when it pertains to grandparents. So a few ways that you can establish standing as a grandparent is if you have had actual care, custody, and control of the child for at least 6 months preceding 90 days prior to filing, right? Or it ends 90 days prior to filing, sorry. So 6 months of actual care, control, and care,
ending,
custody, and control ending.
Not more than 90 days prior to filing.
Thank you.
You're welcome.
Okay. So if you have that, if kiddos have lived with you, or perhaps they've lived with you part-time, or perhaps you have stepped in over the course of several years and you have had the ability to exercise care, custody, and control over these kiddos, that's your standing, okay? Or potentially your standing. Does not have to be 100% or 6 months like all together. You can piecemeal all of this stuff or all the time frames together, but that's one way that you can at least get your foot in the door. Yeah,
so there's a lot to that actual care, custody, control element, right? There's a lot of case law out there that explains it. But basically, layman's terms, what it means is you were responsible for caring for the child and making those decisions for a period of 6 months.
Right. And so things like if you're taking them to the doctor, if you're taking them to school, if they have bedrooms in your home and you're putting them to bed and you're waking them up and you're, teaching them the things that I guess the duties and roles and obligations that a parent would normally exercise, and you're now taking control of that, a case law is going to potentially support the contention that you have standing to be able to file.
And on the flip side, right, if one of the parents is dictating when the grandparent has possession and access, although you may be doing those things while you have possession and access, but the parent is dictating when you have it, then they're going to find that you don't have actual care, custody, and control because that parent is still making those decisions.
Correct. So another way that you can potentially establish standing as a grandparent, and we've seen this unfortunately in some of our cases, is where the parent and the kiddos are living with the grandparents, and something happens to the parent and the parent passes away. Okay, and in that particular case, the grandparents are able to come in and file for conservatorship because obviously kiddos have lived in your home, and so you're able to fight for custody of them.
And I just want to make sure that we're clear on what we're talking about here, because this is standing, right? This is your right to file, not your right to win.
Yeah.
There's an additional burden that we're going to talk about the right to win, but this is just get you in the door to try to argue, right?
Right. So the last thing is kind of, it goes with the standing and kind of the right to win, like Floyd's talking about. So you have to prove what we call significant impairment. And so the grandparent has to prove that the child's present circumstances will significantly impair their emotional or physical, the child's physical or emotional well-being. Okay.
And so that get your foot in the door differs from the right to win, right? How so?
Well, why don't you explain it?
Why don't I explain it?
It's a great idea.
So the right to file, like she said, present circumstances significantly impair the child. Right to win is neither parent should be named conservator or joint managing or managing conservator, which means neither parent should have custody, because if they did, it would significantly impair the child. So that's the right to win burden.
And that's the part that's a lot of times very difficult. So, we've had a case where kiddos had been living with the grandparents, the mother and the kiddos had been living with the grandparents. Unfortunately, mom passes, and dad had, I think, a standard possession order at the time, and he, for all intents and purposes, was a good dad. I mean, he didn't exercise all of his visits. Maybe he came like once a month. Maybe he went for a few months without exercising visitation. But no criminal history, no drug use, no, family violence. There was nothing that he had really done that was wrong that would lead a court to believe that he should not be appointed as sole managing conservator of these kiddos. And even though his access had been very limited and these kiddos had lived with the grandparents and the grandparents had basically raised him along with the mother, we were not able to overcome that presumption. And so in that particular case, we had to work out some agreements in order to make sure that the grandparents had some visitation.
So I think it's important to talk about, you mentioned the presumption, right? So that statute, the right to win, was what we're talking about, right? Is just, it codifies the parental presumption, right? And so the parental presumption is parents should have the ability to make decisions for the child. They should be the one raising their kids. Several courts have found that it's a fundamental constitutional right. And so Texas just took that presumption and codified it into that statute, saying it's presumed to be in the best interest that the parents be named conservator, right?
Right. And so in order to overcome that presumption, as a grandparent, you're going to be held to a very, very high standard. And most of the time when I walk into a grandparents' rights case and I'm feeling very confident, it's because the parent may have been arrested, right? The parent is maybe abusing illegal substances. Maybe the parent is in prison. Maybe parent has been an absentee parent and hasn't come around to visit the kiddo like at all. Maybe that parent hasn't provided any support.
And we've had them where they're, unfortunately, sex-related offenses against the child. Mm-hmm. Those are pretty easy wins. Yeah,
if the parent has had a protective order that has been granted against them. So those types of, and remember, it has to be both parents, right? And so if you have a parent that maybe is doing one of those really horrible things, and then you have a mom that maybe isn't, coming around, but she's not that bad, you might have a difficult time reaching that burden, right? So we have had a case where the mother was in prison and the baby had been living with her parents, actually. I think in that case the father had passed away. And so in that particular case, the grandparents come in, they visit with us, and they're like, here's the situation, and my daughter, is likely going to get out of prison here in the next few months. We're worried that she's going to take the kiddo when she's released. And so we had to get moving very quickly in that particular case, because if mom had been released from prison and if mom had done what she needed to do to take care of business, if we had waited or delayed to get into court, then the court may have found that that we could not overcome the presumption, and that would have been quite unfortunate for those grandparents.
Yeah, because the relinquishment, right, has to be voluntary, right? So if she gets out of prison and she says, "Give me back my kid," right, 90 days after that, you no longer have standing.
Right.
So,
we had another case where we were representing paternal grandma, and the father unfortunately had passed away, and in that case,
you have a lot of people pass away in your cases.
I know, it's not good. But we had a mom that she had these kiddos for a couple years, and she would not allow the paternal grandmother to have any access to him. And so paternal grandma comes in, she tells us what's going on, and on its face, because we knew nothing about the kids. At that point, we don't know where the kids are. We don't know where mom is. We have some posts on social media of mom, but nothing that is concerning. And so in that particular case, we had to go to work, right? And we had to issue some subpoenas to different agencies, Sheriff's Department, Police Department, CPS. We had to try to figure out where mom was living so that we could see if perhaps a private investigator could get involved. And when we start going through these records or requesting this information, we were able to find that her husband was actually not a good dude, and he was pretty violent, and he had been arrested on several different assault charges, and some of which the kiddos were present. That was in the police report. Some of which was against other family members. We didn't have anything against mom, but against that paramour. And so in that particular case, that was sufficient enough for us to establish standing. And in that one, we actually ended up coming to an agreement, because I think the attorney was concerned that if all of that stuff came out, that we would actually potentially win conservatorship in that case. And so we ended up just cutting a deal where the grandma was able to have reasonable access to the kiddo, which she was perfectly happy with. And so
talking about the standing issue, it's kind of interesting, because one of the ways is, and I think what you used in not this case but the case before, maybe this one too, but is that the child's present circumstances would significantly impair the child. But if the child is presently living with grandparents, mom's in prison, how do you argue that the present circumstances endanger the child?
That's actually really good. I don't know. And in that particular case, we, the judge found in our favor, but we didn't even have to make that argument, I guess, because it was presumed that if they didn't have conservatorship, that the child would suffer harm. You're looking at me.
I actually think the presumption is if she got out and got the child, that the child would be fine.
But at that time that we filed, and at the time that we went to court, she could not have been appointed as joint or sole.
Right, so that's the right to win, right, but not the right to file. So I guess you have actual care, custody, and control.
At that point, we had the 6 months for the standing. Yeah.
Okay.
Yeah. Don't confuse me like that. I was like, damn, did we screw that up? No, we were fine. We're good. So what else? What other issues? And I guess going back to kind of that second case that I was talking about, I do think that it's important that you or your attorney or somebody try to do the legwork to kind of see what's going on with that parent, and is there anything that you can find, because we have had that come up on other cases even outside of grandparents' rights where we feel, or the client feels like there's something kind of weird going on, but we can't really prove it, or they don't really know. And then we start issuing subpoenas, we start investigating, maybe we hire private investigators, and we're able to come up with the evidence at that particular point to be able to prove significant impairment. So don't just, be defeated and say, well, I have nothing as I'm sitting here during the consultation, and therefore I'm just going to walk out of here with nothing, because in that particular case, that grandma was like, I have to try something, right? You may not find anything, but I have to try. And thank the Lord that she did, because we did find things, and she did get visitation, and she now has a relationship with her grandbabies because of it.
Yeah, I was going to mention that. I forgot to mention that in the last one, but we sound all doom and gloom in both of these grandparent rights videos, and it's not. I mean, it's difficult, right? But we've won several of them.
Yeah.
Right, and I think the important thing is to get somebody that has experience trying these types of cases and knows their judge.
Right.
Because they are winnable. They're just very difficult to win. So
right.
Don't take this as you don't have any rights, it's impossible, right? Give it a shot, but just know going in that it's not a given in Texas to get grandparents' rights.
Yeah, you got to be ready for the fight. You have to understand that it's likely going to be expensive, and at the end of it, you may not get much of anything or may not get what you want. But especially in these situations where the parent has passed away, I think that in those particular instances, judges are very much inclined to give you something because they want that child to know, the mother or the father, whoever passed, that side of the family. And it's important for that kiddo, not the standard, not the burden. But remember, when we're dealing in family law, there's a whole lot of discretion that these judges have. And so you may have a fighting chance. So
we had talked earlier, or you mentioned earlier, that you thought it was easier to get conservatorship than possession and access, right?
Yeah.
And so the significant impairment burden is the same on both, kind of. And so how do you argue on possession and access that there is significant impairment, but the child should still live with the parents? Or if you're alleging that the child's in danger, right? But the child should still live with the parents. So you're not going for conservatorship, just possession and access.
So you're mixing the two podcasts that we've done now, or the same?
Yeah,
okay.
You had mentioned earlier that it was easier to get conservatorship. So what?
Because what you have to do is, if you're just going for possession and access of your grandchild, is you have to show that the denial of your ability to visit this kiddo is going to cause harm to that child. And a lot of times you don't even have the ability to prove that. You have to show that your presence or your relationship with this kiddo is so very important that if you can't see him or if he can't see you, then that child's going to be impaired. Whereas here the standard's different.
Yeah, and I want to talk about that because that's a lot of times we'll have grandparents come in just wanting possession access, and we strategically decide to go the other route because we have a better chance of winning. And so it's important to explore both those avenues.
Right.
And figure out which one works best.
Yeah, but the trick is finding dirt on the parents. I mean, like, that's as crappy as it is to kind of just say out loud. That's what you have to have. If the parents are good parents, they're taking care of business, and for whatever reason they just don't like you and they're not going to let you see the kiddos, if I can't prove significant impairment, then you're probably not going to have much luck in court.
And it doesn't matter if they're parenting differently than you did or differently than you would, or not taking the child to the school you think he should go to, or not getting tutoring for the child, or not recognizing Christmas or whatever, right?
Right.
Just because it's different, you don't like it, doesn't mean the kid's in danger.
Yeah.
This is a family law property question.
I would hope so.
My father and his wife have not gotten along in several years. They were living together until a few months ago. My father has mild to moderate dementia, and wife expressed that she no longer wanted him living there. So my brother welcomed dad into his home. Father's wife is now demanding that we remove all of his furniture, family heirlooms, and other property immediately, and is threatening to throw them out if we do not do so. She has no immediate plans to move, and this furniture and property is not causing any harm in her home, which has plenty of space. She keeps saying she wants it all gone immediately. We would like to get this done eventually and are working on it, but I live in another state and my brother's very busy taking care of my father, so it's going to take a little while. These are items that are very sentimental and belong to our mother and family. Do we need some type of court order to stop her? We are not sure where to start.
Well, she sounds like a jerk.
She's not very nice. I'm going to start there.
So, number one, if dad has dementia, then they're probably going to need to get some sort of guardianship over dad, because he doesn't have the capacity to, I guess at that point, file on his own. So don't you think they need to start with like a guardianship of some sort?
I mean, I think it depends on what stage of dementia, right?
Yeah.
Isn't it different stages? I'm not a medical doctor, but
Yeah. I think the first issue is going to be determining his competency and whether or not we're going to pursue a guardianship. And so we don't do a whole lot of guardianships, but there's a capacity issue and you have to get letters, like you're saying, from doctors saying that he can't make his own decisions. And then from there, if they obtain guardianship or if he's not incapacitated, he can file a petition for divorce, TRO, or depending on the county, there might be a standing order. And those things will prevent her from destroying or disposing of property or doing all that stuff until you can get into court.
So why couldn't we just do a petition anyway? Right? I mean, Lord knows we have represented some incompetent people.
That's not true, actually, but okay. We'd have big problems if that were true. So, no, we haven't, but...
well, they certainly act that way. They're less than sane. But I think that just comes with the territory, right? All family law. Yeah, it's nuts. Anyways, you can just file the petition for divorce, right? And the sons can help you out if... I mean, I guess it depends on how bad his dementia is, right? If he literally knows nothing about his, right? But if he's on that verge and you just file a divorce and get temporary orders or TRO like you're talking about.
Yeah.
But so the other issue is, so if it were community property, right, then she couldn't get in trouble for destroying community property because she owns it, right? But if we're talking about family heirlooms and it's his separate property, if she's destroying that, is there any criminal liability or civil liability that comes from that?
I don't know about criminal liability. I mean, we've never had that issue before.
We haven't. But it would be his separate property, so she doesn't have the right to destroy it.
Most police are not going to touch that, though.
No, they're not.
Yeah.
They're not.
And then you also have the issue of proving that it is in fact separate property. And then, like, what we see a lot happen in these types of situations is that the spouse comes in and says, oh, well, he took it. It's gone. I don't know. I haven't seen that. I never knew, where it was. And so I always encourage people, if you're, for whatever reason, vacating the residence, do a video or a photographic inventory, right? So you're going to basically go into a room and you're going to take a picture of one wall, take a picture of the other, and we're going to do that for the entirety of the house. Open up cabinets, open up drawers. If there's heirlooms and things like that that you're concerned about, take pictures of them so that we can document on this particular day when we vacated, all of this stuff was there and now it's all magically disappeared. I think you can make a waste claim and you can say, this particular heirloom, the sentimental value, even if it was just a tea set, it's $10,000 to me, and maybe the judge will get so pissed off at her for having destroyed it that we can get some sort of compensation that way. Not going to make them whole, not right, but that's the best that we can do.
Yeah, and at the end of the day, if she just starts throwing crap out of the house, there's really nothing you can do. You got to try to get in front of it.
And my advice would be, go to the damn house and get the stuff out. If you're that worried about it, if it's that much of a sentimental value, then go and get it out. You got to make time to do it. Otherwise, it's going to cost you so much money to deal with those issues on the back end. You're not going to be happy.
How long after the divorce can my ex-wife request her half of the 401k she was awarded but refused to take it when she was offered? My divorce was final in 2016. My ex-wife was awarded half of my 401k. She was to receive $34,000. I provided her all of the paperwork,
Quadro,
and have email records and copies of phone messages asking her to take the money, but she refused, saying she would only take cash. I did not do that. During 2020, I had no work, so I paid the alimony and the child support from her $34,000.
Ew.
From her $34,000. It's gone. Now she's filing to get it.
Oh, no.
Don't put this online.
Yeah.
Contact the criminal defense attorney.
Right.
Remove the post.
No.
Was it posted anonymously?
Please. All together now.
Yeah, it looks like it.
Thank
Okay.
God. Good work. Good work.
Go.
So the money's hers, right? However long it takes for her to get it, it's hers. So basically what happens is in divorces, you have 401k, and what you're talking about a quadro, right? When you're dividing a 401k, one spouse is awarded a certain amount, in this case $34,000. The way that you divvy that up is with a quadro, a qualified domestic relations order. And so you'll send that off to the 401k company or whatever, and then they break it off into a separate account. Okay. But until such time as that quadro's done and it's separated, it creates a trustee relationship. And so he's essentially the trustee of that $34,000 that is hers. And it's not his to spend. And so, there's all kinds of problems that come from spending money that's not yours. And so he's going to have to give her that money.
So I just had this issue come up. And it was kind of goofy. So the way that we had to enter the quadro, we had to go to court because the husband in this particular case was not being agreeable to the amounts and all sorts of stuff. And so judge tells us, sit down and Ms. Jimenez, I want you to pull up on his 401k statement to determine the value of marriage and the value at the date of divorce, because there was some goofiness going on with that. So I'm like, sure, judge, no problem. So he and I sit in the courtroom. He pulls up his account, and we're looking at past statements. And as we're looking at past statements, I noticed that the present value of the account is 0. And so
That's a problem.
And so I was like, did that say 0? And he's like, well, yes, ma'am, it did. And I was like, so where did it go? Where is it? And he said, well, I moved jobs, or I lost my job, and so I rolled it over into another account. But I, of course, couldn't see the account. I don't know at present if the account is actually in existence or if he actually has the money. And so we go through, we do the figures, and then at the end of the hearing, judge is like, okay, well, I'm going to go ahead and sign this qualified domestic relations order. And I say, pump the brakes, judge, because that's not going to do me any good, because that account is no longer in existence. And
pump the brakes, is that legal terminology?
Yeah.
Okay.
Yeah. And so needless to say, that judge was pretty upset with that individual that had moved the funds. And so we're set for another hearing, and hopefully at that hearing I'm presented with a certified check for the funds, and everything is A-okay. We shall see. But the thing that's kind of wonky about it, also a legal term, yes,
got it. I saw that in Black's Law Dictionary.
Is whenever you're doing a qualified domestic relations order, part of the final decree of divorce and the quadro is that the person who is awarded the amount of funds is entitled to all gains and losses. And so typically there's going to be like stock shares, et cetera, right, that make up that 401k account. And so if those stocks go up, and let's say hypothetically it was $30,000 that this wife was supposed to receive, any gains on those shares, she would have more money. And if the stocks had gone down, then maybe it would not have been the $30,000. Maybe it would have been 27 or 26. And so bottom line is, don't touch it. Like, just don't touch it. If your spouse gets a 401k account, don't screw with it, because you're going to end up in some big trouble.
So you're going to go down a rabbit trail?
Yeah, let's do it.
Let's go down a rabbit trail. You like rabbit trails.
I do.
Part of the question was she wanted it in cash, right? Mm-hmm. He said it was supposed to be a quadro. And then in your case, you said you're hoping to get a certified check, right? And so are you hoping to get the certified check for the entire amount, or the entire amount less the fees it would cost to withdraw from 401k?
The entire amount.
Why? If it was going to be withdrawn, right? If she's going to get cash, that's not how much. If she was awarded $50,000 and she pulls it out, she doesn't get $50,000.
If she pulls it out of a quadro. right? If she pulls it out of the retirement account by virtue of a quadro.
Right.
Okay.
Which is what she would have had to have done if he hadn't taken the money out. That's the only way she could have gotten cash. She would have had to pay that 20 or 25% penalty on it.
Mm-hmm.
Right. And so if he took it out and paid that penalty, why is he now having to give her the entire amount when she would have been responsible for that penalty?
Because he took it out. And
That was
he
a
should
dumb
not
move.
have done
That was
it.
a dumb move.
Yeah. So he shouldn't have done it. So now I'm going to take the full amount.
Oh, wait. We represent
We
wife?
represent wife.
Oh, good. Yes.
Yeah,
He needs to
hell
pay
yeah.
the full amount.
I was like, why are you asking this question?
I thought
Of course, I'm going to take the full amount.
Yeah.
But if I represented husband, I would have said, Judge, we had to pay penalties and taxes on this. But no, so, and that's the other issue is a lot of times people don't want to issue the quadro for whatever reason. They don't want to issue it. And I've also been on the opposite end where I will tell my client, so let's say I've had this where the husband's the one who's supposed to has the retirement account and he's supposed to give the money to the wife, and the wife is responsible for doing the quadro. That's typically how it works because she's the one that's receiving the money. But we have gone ahead and just said, let us do the quadro, let's get it processed, let's get this account severed, because I don't want you ending up in that sort of a situation in the future where you might make a move, you might, need to take out the money, you might need to take a loan, and we have issues. And so it's better, and actually it saves you money if you do it within 30 days of the final decree being filed.
Yes.
You don't have to pay filing fees, etc. So the best practice is get it done immediately.
And whether or not, in this case, she was entitled to cash or just by virtue of a quadro depends on how the decree is worded, right? So I've done it sometimes when I'm the one getting the portion of the 401k where I would require them to pull the cash out so that my client's not incurring those fees.
Mm-hmm.
And so if it was done that way, then he would have had to have given her cash. But we're on the other side. We just want to do a quadro. If they did it that way, then she wouldn't be entitled to the cash.
Well, and then I have, which I actually need to discuss this with you offline, now that he's going to be potentially giving her a certified check, what are the tax consequences of all of that? And we're not tax attorneys, but that's something that I was like, typically whenever you're doing a division of the estate by virtue of a divorce decree, there's no tax consequences because it's property that's already yours and you're just dividing it by virtue of the divorce, right? In this particular case, because there's now an exchange outside of that decree, I don't know if that's going to create issues, but it's very, very messy. And I think, luckily it just happened to play out that I had to look at his account, because otherwise I would have issued a quadro and then I would have received a letter from the 401k company saying, hey, there's no money in this account, and that would not have been good. Yeah.
Facts.
Yeah.
Emergency sale of a home during divorce. My ex-wife has delayed the divorce with a falsified restraining order that we have been in trial on for over a year. I was extorted into signing a temporary spousal support agreement where I paid 80% of my net income to my ex.
Holy cow.
I say extorted because she also framed me for domestic violence, which my divorce attorney said I would have to agree to the outrageous support amount, or we would go to trial in the civil restraining order hearing and my words would be twisted and then later given in criminal court to the prosecutor to use. The criminal DD has been dismissed, but the support order remains, and I've had to pay my ex's bills, including her car, insurance, and the house. I was forced out of the house with the restraining order and had to get an apartment, so I had to pay the mortgage and my living expenses also. My question is, I've run out of savings to pay for everything, and the house is going to go into foreclosure. What consequences are there for requesting an emergency sale of the house prior to the RO trial being finished? My current lawyer is saying it's going to be my fault for signing the agreement and then not following it, but I signed it under duress and it was supposed to be short term.
Maybe this guy needs a new attorney.
Yeah. I think maybe he has a new attorney, just like my current attorney is saying this, so I feel like maybe he made the switch. So did he say there was a domestic violence at the beginning of the case?
False domestic. He's been framed for it, yes.
Okay.
And there was a civil PO.
Okay.
And it sounds like they agreed to this spousal in exchange for dismissal of the PO.
Okay. Yeah, that sucks. This whole thing sucks.
That's great advice. You
Yeah.
are killing it.
Next question.
Good luck, sir.
Okay, so here's the problem. Ugh, these are the worst. Okay, when you have a family violence case, and you're being accused falsely, or perhaps you actually did it, it impairs our ability to present evidence at a trial as it pertains to those issues. So what's going to happen is wife's going to get on the stand and she's going to say, hey, my husband did X, Y, and Z, and husband, when you take the stand, you're going to have to invoke your fifth, right? Because there's potential criminal consequences. And I would say 9 times out of 10, we do that. The other 1 out of 10, it is because our client legitimately did not do it, and perhaps we have evidence to prove that it's not true, and we have text messages or other documents to prove that the wife is making all of this stuff up. And so in those cases, we just get up there and we tell our story, right? But that is a very rare occasion, and that is only done after lots of conversations with a client and with each other, because that's a very, very big risk, because you're opening yourself up to cross-examination, and anything that is said in a civil case can be used against you in a criminal case as a judicial admission, because you're sworn in, you're testifying under oath, and that can create big problems for you.
Yeah. So it said that the criminal case has already been dismissed. So
Now, but at the onset of the case, that was the problem.
right, but why have they not been back on a modification of temporary orders after the dismissal of the criminal case?
I would absolutely have done that. And
That's a great idea.
also,
Why don't you tell us all about your
yeah. So my plan would be to go back on a modification of temporary orders. But the other thing is I don't know. I mean, we don't know the courts. We don't know all the other facts. We don't know mom's situation. But most judges, if you had even gone on a contested hearing, would not require that 80% of his net income be paid to the wife.
So we're going to take this guy at face value. That's where we're going with this?
Well, let's do that first.
This sounds like one of those, I've been framed and fake TRO and 80%. It sounds like one of those clients.
Well, that's the freaking question. That's the fact pattern that we've been given.
I mean, yes, it happens. But if this were my client, I would dive in and make sure he's not full of crap before I try to sell this story.
But this is the story. This is the fact pattern, Floyd. So go with the fact pattern that you've been given, and that is
80% is a heck of a lot. I don't know.
Well, and maybe the attorney did agree to that. We've seen
80%.
We have seen attorneys that have agreed to that before. And that is not something that we would likely do, but we've seen it done. And in rare occasions, we've actually, I guess, very rare occasions, have seen that happen in some of our hearings. Normally really bad fact patterns associated with it. And maybe this was one of them, right? But what I will say is, obviously attorneys are legal counsel and we're supposed to counsel you, but at the end of the day, it's your decision. And I cannot, it frustrates the hell out of me when we have a new client that was previously represented by another attorney and they're like, well, I didn't have a choice. I had to agree to this. I didn't have a choice. And my lawyer told me I had to agree to it. You always have a choice, right? You may not like the choices that you are given, but you have a choice. And so make sure that you're having these hard conversations and you're really thinking about what you're doing. Because in this particular case, he made a very, very bad deal that now he's going to have to live with.
Or maybe he made a good deal, right? So taking it at face value, right? What if what the attorney was saying was true, right? What if the facts were not favorable to him? Mm-hmm. And if they went to court on a PO, mm-hmm. it would be used against him in a criminal case. And like you said, he didn't like his choices, right? But at the end of the day, it was his choice not to take the chance to go to the PO hearing and take a chance on those statements being used in a criminal case.
Well, but he didn't have to testify at a PO hearing.
He didn't have to, no. Right. He didn't have to. But that's what the attorney had told him. So taking it at face value, right? We're going to take the facts as they are. He was advised
Glad you're doing that.
That if he went to a PO hearing, that his words would be twisted and they would be used against him in a criminal proceeding, which sounds like this attorney maybe had plans for him to testify.
Okay.
And so if this attorney said, look, you can go to PO hearing, this is what's going to happen if you're insistent on testifying, right?
Mm-hmm.
Or we can take this deal and potentially absolve you of any criminal liability.
Or you could have gone to because we've done this too, right? Because a lot of times what we'll do is we'll represent clients on criminal and family law cases. And that's actually our preference because we kind of have control over everything. And so sometimes we want to have the opportunity to question the alleged victim on what they're going to say in a criminal proceeding and to kind of poke holes in her particular case. And so maybe it would have potentially been beneficial for him to have the PO hearing, not have his client testify, get all the information from the alleged victim, and then use that to then go to the prosecutor to get the case dismissed. And we don't know what happened as far as possession and access, right? Because I don't know. Did he say he had children? No?
No, you're just going to make up facts.
Okay, so
right?
Now we're not going to take the facts at face value.
Oh,
and we're
okay.
going
We're going to assume
say,
there's kids.
now there's children, right? And so
the other 20% of income is child support.
Right. Okay. So the problem with protective orders is if they are granted, then it's going to potentially affect conservatorship and possession and access. Not potentially, it will affect that, okay? And so by maybe agreeing to this other stuff, maybe he was able to save his relationship with his children, which those are the choices, right? You're going to get screwed on the financial end, but you're going to actually be able to see your kids and make decisions pertaining to them. Not great choices, but that's potentially it. Maybe his previous attorney knew that if they went in on a PO, it was going to be granted, and this particular judge was going to limit his access, and maybe he would not have been screwed as much as he was on the financial end, but it would have impacted his kiddos. So these are all they're tough choices.
Yeah, I mean, it's difficult when you are following the facts and make up your own facts and kind of mixing them back and forth. It's really hard to give a proper analysis when
no, he has kids.
It's fact subject to Miss Jimenez, right?
Okay, so if he didn't have kids, then the first analysis was good. If he does have kids, the second analysis is good. But the question really is he going to get in trouble for not making the payments?
Potentially. Right, so they could file an enforcement against him, right? But he has affirmative defense, inability to pay. Mm-hmm. If in fact that's true, but are we going off the facts on the income part of it? Like he can't afford it?
Yes.
Okay. So going off the facts on this portion of it, since Ms. Jimenez said we can, then he would have an affirmative defense of inability to pay. And so he could go in and prove that he legitimately did not have the money to pay what he violated, the portion of the order that he violated, and then he could not be held in contempt for it.
What about if they are behind on payments and or they have to sell the house at a reduced price and they take a hit there because he wasn't able to make the payments, etc.?
I don't know. I think I would want to know more. I think if he legitimately cannot afford it, I don't know that a court holds that against him. I mean, maybe he should have gone back on a modification. Maybe because he didn't, the court holds it against him.
But see, that's always kind of the other problem when you're dealing in these cases is a lot of times there are things that you should do, right? Like in this case, going back on a mod. But then he's saying, I don't have money, right? I'm broke. I'm giving 80% of my income. And the lawyer's probably telling him, well, we need to go back on this mod, but it's going to cost you X number of dollars. And he's like, I don't have those dollars. And so now I just need to wait for a final hearing, right? And so again, more tough choices, more difficult choices,
and more facts added to this fact pattern that wasn't in there initially.
No, because he said he didn't have money. He said he was broke, that he couldn't even pay the mortgage.
He did not say the attorney was telling him that he should go back on a modification.
But that's what we're saying.
Right, adding facts. That's what I meant.
So here's the I guess, big point that should be made. And that is that when you are choosing an attorney, choose the right one up front because then you may not end up in this particular situation, because based on the fact pattern and taking it at face value, it may be
Sometimes.
that this attorney may not have been as knowledgeable as he or she should have been, and then you end up in a really, really bad situation that is going to cost you a lot more money to fix, and maybe it's not even salvageable, right? And we've definitely had clients like that have hired previous counsel, sometimes 3 or 4 previous counsel, and then they come in and they hire us, and it takes us a lot more time and a lot more money and a lot less guarantees that we can give the client to fix those issues.
And it just may be a situation where we're Monday morning quarterbacking this guy, and at the time it seemed like the right decision, right? But now in hindsight, you're like, I screwed that up. Now, I haven't had that experience. I know you have, right? Because I usually just get it right the first time, but that may be the situation here.
Right. So with that being said, thank you for watching the consultation. So as we always state, please don't accept this as legal advice. It's more for informational purposes. If you find yourself in this situation, please go and consult with a local attorney where the children reside, because that's going to be your venue, right? And talk to them, tell them your fact pattern, encourage them to potentially investigate. I want you to investigate, because I do think that grandparents are very important and they should have a relationship with their children. And so don't give up the fight, even though we know that it's going to be difficult, okay? Follow us on social media platforms, Instagram, Facebook, TikTok, etc. And thank you guys for watching.
Should we maybe wish all the grandparents Happy Grandparents Month?
Yeah, happy Grandparents Month. Love you, Momo.